In the previous video, I reviewed two cases, Universal versus Sony regarding the Betamax, and RTC versus Netcom about the legal responsibilities of online service providers. Both of these have proven to be very important to the applications of copyright on the internet and other modern technologies. Here, I want to continue the discussion by addressing peer-to-peer file sharing services and whether their operators or software distributors have any responsibility for the infringing activities of the users.
So let's start with Napster, which was launched in 1999 by two individuals, Sean Parker and Sean Fanning. Yes, they're both Seans. One is S-E-A-N and the other is S-H-A-W-N. Actually, you may be familiar with Sean Parker because he appeared in the movie The Social Network, which is about Facebook. He's the guy played by Justin Timberlake, who had the somewhat memorable line in which he insisted that the service should not be called The Facebook, but simply Facebook. Oh, just as an aside, my daughters loved NSYNC when they were young. You know, the band that made Timberlake a household name. And I used to disparage them, as fathers liked to do back then. But now I have to confess that Justin Timberlake is a tremendously talented individual. He was very good in this movie. I also highly recommend that you find clips of his appearances on Saturday Night Live, which are hysterical and demonstrate his versatility as a singer, dancer, comedian, and actor. It does turn out he's pretty incredible. Anyway, back to Napster, which became an enormous threat to the recording industry when it came on the scene. And you will have to step back in time for a moment because in 1999, most of us still got our music on CDs that we purchased at the music store for about $15 per album. So this is what I could do with Napster. First, I would download the software. Then I could put one of my purchased CDs, let's just say Who's Next by The Who, in the CD drawer and upload the music from the CD onto my computer into a music file with MP3 format. Then I could move the album or separate songs into a Napster library folder that came with the software. So let's say that I put the song Won't Get Fooled Again into the folder. I also can name the file anything I want, and so I call it Won't Get Fooled Again, The Who. The Napster software then transmits the title I provide up to its servers onto a list of songs that are available from all the system participants. Thus, another Napster user could search through the list of names and perhaps specifically for the words Won't Get Fooled Again. And my title would appear along with those uploaded by other Napster participants. That user then can select one of the listed titles, which might be mine, and that would start a process that would transfer the Who file directly from my computer to the requester's computer. And voila! He has now gotten a copy of Won't Get Fooled Again for free. But beyond that, the recipient can now put the music file in his Napster library folder so that it also is made available to other users. And those that download from this person can also do the same. Thus, if you kind of pencil this all out, you can see that beginning with just a few CD uploads, there can soon be a Malthusian explosion of music files available for free from computers around the world. It quickly became clear to the music industry that if Napster were allowed to survive, very few customers would be willing to pay for music, given that almost everything would be available on Napster for free. Now, of course, the industry might sue me for reproducing The Who's next album to my personal computer and then distributing files to other Napster users from my Napster library folder. They also might sue those who download from me for reproducing the files on their computers. Now, I might argue that the copies and distributions are fair use, but as we will see, I would ultimately lose. Thus, the industry does have recourse, but that would mean uncovering my violations, suing me, and then learning that I don't have sufficient assets to pay a judgment. And the same would be required to stop everyone else. It would be a litigation nightmare. For this reason, the industry sued Napster, claiming that it was legally responsible for the infringements by its users. Okay, before looking at the court decision in this case, I want to point out a couple of things. First, this kind of technology is called peer-to-peer because the music files are transmitted directly from one customer's computer to another customer's device. Contrast that with how an ISP operates. For instance, in Netcom, the minister posted the materials up to Netcom servers and others then downloaded from Netcom. So imagine that if the volume gets really high, then there might be a bottleneck as Netcom servers and bandwidth constraints attempt to manage the demand. Peer-to-peer systems actually can avoid some of these bottleneck issues because the large file distributions are decentralized and don't all travel through a central node. Instead, they rely on the user's computers and their transmission lines, which have plenty of available throughput. Thus, although some uses of peer-to-peer systems might be unlawful, the systems may also provide significant social benefits. All right, now to the court decision. The first stop was the district court, which found that Napster was liable for copyright infringement. Napster appealed to the Ninth Circuit Court of Appeals, which reached its decision in 2001. I have to tell you that this is a very confused opinion, but at the end of the day, the court made the right call, in my view. Okay, so the court begins its analysis by discussing how the Sony case might apply to the outcome. To do this, the Ninth Circuit considered whether there were substantial non-infringing uses of the Napster system. The assumption here is that under Sony, if the technology could only be used in substantially unlawful ways, then Napster should bear responsibility for those outcomes. The court then appraised whether, at the time of trial, any Napster customers were involved in non-infringing activities over the peer-to-peer platform. So it acknowledged that a few recording interests gave permission for their works to be shared, but the numbers were not sufficient to be considered substantial. Thus, almost all the users were making unlawful reproductions and/or distributions unless their behavior could be justified as a fair use. Napster responded that users were indeed making a fair use. It opened by saying that all of them were doing so. How's that? Well, it tried to justify it by weighing the four factors and relying a lot on what it claimed were the personal non-commercial ends of its customers. But the court didn't buy it. First, it discounted the notion about non-commercial use, since the users were repeatedly getting free music, which they otherwise would have to buy. The actions also weren't personal, since the files were made available to others on the network. As to the other factors, the music was creative, the users copied entire songs, and the availability of free online music harmed CD sales and opportunities for the music industry to introduce its own fee-based online services. So the court found that the typical Napster participant was not engaged in a fair use. Napster then argued that although many users did not make a fair use, there were a couple sets of individuals who did meet the fair use standards. For instance, Napster said that some individuals might use Napster to conveniently listen to their own music library without having to tote around their CDs. In other words, if I were traveling and I didn't want to carry my CDs, such as Who's Next, then I could upload it to my Napster library folder and then download it on a device at my destination. So this is that notion of personal space shifting, which I noted as a possible corollary to time shifting. A fair use, according to the Supreme Court in Sony. But the court discounted the argument here, finding that my upload to the Napster library makes it available not only to me, but to others. Thus, it may be space shifting, but not personal space shifting. Napster also argued that Napster provided opportunities for users to simply sample music for free, and that they would then buy the full CDs if they liked what they heard. The court again determined that even if some Napster users did this, it still was not a fair use, mainly because free samples prevented the music studios from earning royalties from their own sampling services. Thus, after dispelling all these arguments, the court determined that almost every current Napster user infringed copyrights. Having said all that, the court then acknowledged the efficiency of the overall peer-to-peer design and noted that it thus might be an excellent platform for non-infringing uses in the future. And so the court was worried about perhaps shutting down a software provider, even if current users find it useful to infringe, when that software has the potential to facilitate non-infringing distributions in the future. For this reason, the court stated that potential non-infringing uses in the future are relevant to find provider liable under Sony. And since Napster, in the court's view, might have substantial future non-infringing uses, it determined that it could not hold it liable under Sony's principles. So remember this conclusion, because it will be relevant in our next case regarding Grokster. But interestingly, after going through all this, the Ninth Circuit determined that the Sony case wasn't really relevant to how Napster operated. Recall that a key factor in Sony was that the manufacturer had no control over how customers used the product after it was provided to them. Napster, though, was not in this position. Rather, when a user put a file in the Napster library folder, the file name was stored on Napster's computers so that others could find it. Since Napster owned and controlled these servers, it had the technical ability to remove file names if it chose to do so. Due to this control, Sony was not the correct model to appraise Napster's legal responsibility. Rather, the court ruled that it should be viewed through the lens of the Netcom decision. And in this regard, the court evaluated whether Napster should be held liable for contributory and/or vicarious infringement. So looking first at contributory infringement. The question is whether Napster knew of user infringements at a time that it could have prevented further violations. And the court said the answer was yes. For instance, if the copyright owner of Won't Get Fooled Again notified Napster that its music title was listed in file names on Napster's servers, then Napster would have an obligation to prevent further infringement by removing the names associated with copyrighted work. Now, Napster users were smart, and so once names were removed, users would just put them back up. Thus, the recording industry might have had to continually notify Napster of new listings, which could have presented an overwhelming task. Also, the users engaged in trickery, such as writing the names in Pig Latin. So, that they were different than what was flagged, but users could still find them. Thus, the notice provided to Napster may have been imperfect, which could have possibly shielded it from some liability. But here is where vicarious liability reared its ugly head, because unlike Netcom, the court determined that Napster profited from the availability of the infringing materials on its system. Although the Napster software was free, the court believed that the company's business plan was to increase its customer base, which would lead to money-making opportunities down the road. For instance, Napster might one day introduce advertising onto the system, which would increase in value with potential customer reach. The court also determined that the infringing content served to draw customers, and thus it tied the infringing material to Napster's potential commercial success. So remember that when there is vicarious liability, then the operator does not have the luxury to simply wait for notice. Rather, it must actively police its system to rid it of infringing content. This then put an active duty on Napster to disable file names as they were continually reposted, and to uncover the tricks utilized by participants. And so Napster not only could not do this, but there would be nothing left if it did. For this reason, Napster loses the case and the court orders it to shut down. The company then entered bankruptcy until it reemerged with a legal platform that was purchased by Roxy. And I believe that the company still runs a form of the service today. And so that is the end of the Napster story. Score 1 for the recording industry. Okay, after the Napster decision, the peer-to-peer industry responded by creating more decentralized networks that it thought might pass muster under the Napster decision. Some of the initial big names, Grokster, Streamcast, and Kazaa, were involved in the landmark Supreme Court litigation that we will review shortly. There were several others, such as Audio Galaxy, LimeWire, and iMesh. Beyond filing lawsuits against the peer-to-peer services, the recording industry engaged in other strategies to address continuing massive infringements over the web. One of the tactics was to ramp up copyright infringement suits against the individual file sharers, hoping to deter others who might then see the risks. Most of these legal actions were filed against large infringers, but sometimes they even pursued young teenagers who were sharing music from their attic bedrooms. These, of course, were not about the money, but rather to make it loud and clear that nobody was too insignificant to escape their attention, so everybody should be very afraid. The recording industry also tried to incorporate technical security measures. For instance, some technologies were incorporated in CDs to prevent uploads to computers. Others limited the number of devices that could play a recording, which served to choke widespread file sharing. These efforts sometimes did not work, or were easy to circumvent. Also, many customers resented the inconvenience. Beyond these efforts, the industry adapted by providing access to music at a more reasonable cost over authorized download services, such as iTunes. The notion here, of course, was why take the risk of being caught using illegal services when you could get high-quality music legally for around $1 per song? Anyway, what I want to focus on here are the cases against the decentralized networks, because choking off easy access to free music was a key element to the overall response. And this brings us to the historic litigation against Grokster et al. Okay, let's set the stage for a moment. The file-sharing companies learned from Napster that they were vulnerable because the system operators maintained control of the content distributed over the networks. Remember that Napster lost because it had the ability to remove file names of infringing music from its servers. Thus, the industry developed new technologies that allowed files to be shared without involving the promoter's computers. One of these new designs was called Gnutella, which was used by Streamcast, among others. So this is how Gnutella basically worked. Let's say I had downloaded the Streamcast software and put my music in the Streamcast library folder for others to find. One of the songs is Won't Get Fooled Again. Let's say someone else with Streamcast wants to download the Who's song and so requests the system to find it. With Streamcast, their computer would search each of the computers on the system until it found one, perhaps mine, that had the requested file name in the library. Once a source was found, it would then initiate the download. Thus, after Streamcast distributed the software, the system effectively worked on its own. Indeed, if Streamcast went out of business, those who already had the software theoretically could keep sharing songs. The other system, called Fast Track, operated in a similar fashion but with greater efficiency. Although Gnutella was decentralized, it was a little clunky because the search went from computer to computer until the desired file name was matched. Fast Track identified relatively powerful computers on the system and used them as nodes to store file names of music available from other participants. Think how with Napster, all the file names and requests went through its computers. With Fast Track, the requests went to select computers on the network which stored the file names from sets of users. The end result was the same, just faster. Grokster and Kazaa both relied on Fast Track. So let's be clear about a few things. The software distributors of these systems were a little like the seller of a VCR because once they provided their product to customers, they had little or no control over how they were used. The systems also could be used for sharing other content besides music, such as movies or personal documents. They also operated efficiently because the decentralization allowed them to avoid potential bottlenecks. Thus, although customers initially used the system almost exclusively to share copyrighted music and films, the technology certainly held great promise for significant legal use in the future. The entertainment industry, of course, was alarmed and brought suit in 2002 to stop further distribution of the software. And everyone piled on. Recording companies, movie studios, songwriters, you name it. They argued, as in Napster, that the software distributors were responsible for the unlawful conduct of their customers. You know, all those infringing copies and distributions that they made without permission. And trust me, everyone at that time was watching this case. It was just huge. So, the district court granted summary judgment for the peer-to-peer services, and the Ninth Circuit Court of Appeals affirmed. Summary judgment means that they were able to decide the case without a full trial, because even if everything the entertainment industry alleged were true, they would still lose. The industry was shocked. I mean, devastated. But you can see how the Ninth Circuit kind of teed this conclusion up in its Napster decision. I mean, all that seemingly irrelevant discussion of the Sony case in Napster just played into the file-sharing company's hands in this situation. Because, again, the file-sharing services were able to successfully argue that their software was capable of significant non-infringing uses in the future. However, unlike in Napster, they were able to demonstrate that they could not prevent copyright infringements over the system because they did not own or control the computers where the file names were searched. Thus, the court could not fall back on Netcom to find them liable, but instead had to rest with its conclusions regarding Sony. And relying on Sony, the court ruled for the file sharing networks due to the software's potential for efficient lawful uses. In reaching this decision, the court also made it clear that it did not want to shut down a new technology that had so many potential social benefits before it could even get off the ground. Thus, unless things changed, the entertainment industry was going to have to combat infringements over these systems in other ways. The movie and recording companies, of course, immediately appealed to the Supreme Court, and they were supported by numerous advocates who argued that the result threatened the foundation of the entertainment industry and other copyright interests. The peer-to-peer businesses found support as well from hardware companies, software developers, and internet freedom advocates. And trust me, when the Supreme Court agreed to review the case, the whole world stopped still and awaited its decision, which came in 2005. So, after all this controversy and division about the outcome, the Supreme Court ruled unanimously to reverse the decision of the appeals court. Why was the Ninth Circuit's analysis wrong? After all, the network companies didn't have control, and the systems did seem capable of non-infringing uses. So how did the appeals court somehow apply Sony's concepts incorrectly? The answer is that the underlying principle for establishing liability is that the company supplies a product with the purpose of facilitating infringement. So think back to the gun shop that sells a regular gun. If the customer then shoots an elephant seal, you told me that the seller should not be responsible because he had no control. Nor could we tell that he wanted the customer to act illegally. Given all the possible lawful uses of the gun, we can't assume that he had nasty motives. Maybe he thought the customer would go to the shooting range or hunt pigs during pig hunting season. So, when there are significant lawful uses of a product, then we can't infer an illegal purpose simply from the sale of the product. Now, if there is other evidence demonstrating unlawful intent beyond the mere sale of the gun, then liability would be appropriate. Remember what you said when the seller indicated that it's fun to shoot elephant seals and provided a silencer to help the customer get away with it. Also, you told me if the gun can only shoot elephant seals, then we also could infer an unlawful intent, because why else would you sell it? Anyway, by applying these principles, Sony was not liable for infringing uses of the Betamax because many customers use the machine to time shift, which is a lawful fair use. However, had there been evidence that Sony encouraged customers to use the machine to infringe copyrights, let's say to library recordings, then it might have been liable when the customers followed those suggestions. But there was no evidence that it did so. Thus, the question with the peer-to-peer systems was not simply whether they were capable of substantial non-infringing uses, which perhaps they were if you look to the future. In addition, one needs to consider whether the firms providing the software encouraged or induced users to engage in copyright infringement. And the court suspected that if a judge or jury were to look at the evidence, it might conclude that the networking firms did want customers to infringe. Why did the Supreme Court believe this? Because there were several pieces of evidence which together might lead a decision maker to conclude that the firms acted with unlawful intent. For instance, when the plug was pulled on Napster, the file-sharing companies solicited former Napster customers who they knew were engaged in infringement before and tried to attract them to their services to satisfy their needs. The companies also could have included filtering technologies to deter sharing of copyrighted files, but chose not to do so. Remember with the gun example when I asked your opinion if the seller could have added an inexpensive component that would prevent shooting elephant seals, but the seller did not do so. That raised the question of why make that choice? And you could infer that the seller didn't include it because he wanted to satisfy those potential customers who were interested in shooting elephant seals. The same reasoning might apply to his decision to not include filtering tools. That could be at least some evidence that the file-sharing firms actually wanted their customers to continue infringing copyrights. In addition, the court recognized that the defendant's business model, which was to attract a large customer base, depended on high-volume infringement. So, all of these considerations might be enough to convince a reasonable person that the peer-to-peer companies encouraged their customers to copy and distribute copyrighted files. From this, the court concluded that the lower courts were wrong to grant summary judgment in favor of the defendants. Thus, it sent the proceedings back to the trial judge to reconsider his ruling in light of the Supreme Court's explanation, and suggested that summary judgment for the entertainment companies might even be appropriate. To do that, the judge would have to find Grokster and the others responsible, even if everything they allege were true. One question that this case left hanging was what might have happened if the court had not found supporting evidence that the peer-to-peer companies intended to facilitate copyright infringement. In this event, it might have been necessary to address whether the platforms enabled sufficient non-infringing conduct to make their purpose ambiguous. That is, are the networks like a regular gun, or a gun that realistically only shoots elephant seals? Are they like VCRs, which enable substantial lawful activities? Or are they like a device that really has few lawful applications? This raises the question, how much lawful or non-infringing use is sufficient for the firms to escape liability? That has never been answered satisfactorily as far as I know. Also, should potential future non-infringing uses count, as the appeals court stated, and if so, how should they be weighed? At the moment, we still don't definitively know the answers to these questions. How did this all end? Well, Grokster pulled the plug and ceased distribution. Streamcast fought on for a while, but the lower court granted summary judgment for the entertainment industry in 2006. Kazaa was found liable in Australia and entered a global agreement that terminated its illegal service. Thus, in the end, this was another big win for the entertainment industry. All right, it's time to wrap this up. I'll try to pull this together and answer your questions in the class session.